The highest court in the most powerful nation on earth just told its own president that what he was doing was illegal, and his response was not to comply, not to negotiate, not to appeal through proper channels. His response was to do it again, harder, and through a different legal door. That is not a political headline. That is a constitutional stress test playing out in real time, with consequences that stretch far beyond American borders. TC explains here. And today we are going inside the ruling, the response, and the deeper structural shift that almost nobody is connecting to the full picture. Before we go further, one thing you should know about this channel: everything analyzed here is grounded in verified reporting, publicly available data, and documented institutional behavior. We do not speculate without evidence. We do not pick political sides. What we do is connect what the headlines report to what the headlines miss. That distinction matters more today than it ever has. So if you are someone who wants to understand the world rather than just react to it, you are in the right place. Here is what just happened. The United States Supreme Court issued a ruling that struck down President Trump's emergency tariffs, the sweeping import duties he had imposed on goods from dozens of countries using the International Emergency Economic Powers Act, commonly known as IEPA. This law, passed in 1977, was designed to give presidents rapid economic tools during genuine national security crises. The court ruled that using it as a blanket authority to restructure the entire global trading relationship of the United States exceeded what Congress intended when the law was written. According to Reuters, the ruling was historic in scope. It represents one of the most significant judicial checks on presidential trade authority in modern American history. The justices did not rule on whether tariffs themselves are good or bad policy. They ruled on a fundamental question of constitutional authority, and they said the president went too far. The immediate international reaction was swift and cautious at the same time. The European Union, America's single largest trading partner, issued a statement saying it was carefully analyzing the ruling and remained in close diplomatic contact with Washington. That measured language from Brussels is important to read correctly. The EU has been preparing retaliatory trade measures for months. The fact that they did not immediately celebrate the ruling tells you something. They have learned not to assume what comes next from this administration, and they were right to wait. Because within hours of the ruling, Trump signed a new executive order imposing 15% global tariffs, this time using the Trade Act of 1974 as the legal foundation rather than IEEPA. Let that sink in. The Supreme Court blocked one road. The White House immediately found another one. According to the Wall Street Journal, trade lawyers and constitutional scholars described the move as aggressive and deliberately designed to test the boundaries of a different legal statute. The new tariffs can legally remain in effect for a maximum of 150 days without congressional approval, which means the clock is now running, Congress is now the next arena, and the legal fight has simply moved to a different battlefield. This is where things get interesting for Barr, because most coverage of this story focuses on the political drama. Who won? Who lost? What does this mean for Trump's poll numbers? But the deeper structural question is something entirely different. What this moment actually reveals is a fundamental tension inside the American constitutional architecture between executive economic authority and judicial oversight. That tension has been building for decades. Trade policy has historically been a congressional power. Article 1 of the U.S. Constitution explicitly gives Congress the power to regulate commerce with foreign nations. Over the past several decades, Congress has progressively delegated more and more of that authority to the executive branch through statutes exactly like IEPA and the Trade Act of 1974. What the Supreme Court just did is begin the process of pulling that delegation back. This is not just about tariffs. This is about which branch of government controls the economic levers of the world's largest economy. And the answer to that question is no longer settled. Now, let us bring in the global economic data because the numbers tell a story that the political framing tends to obscure. Bloomberg reported that the uncertainty created by the original tariff regime had already contributed to a measurable slowdown in cross-border investment decisions through late 2025 and into early 2026. Companies with global supply chains had been delaying capital expenditure decisions, waiting to understand what the trade environment would look like in 12 months. That kind of investment paralysis does not show up in one quarter's GDP figure. It accumulates silently and then surfaces suddenly. The Financial Times noted that the 150-day window on the new tariffs is actually more destabilizing in some ways than a permanent tariff would be, because businesses cannot plan around a policy that may or may not exist in 5 months. Uncertainty, not the tariff rate itself, is often the most economically damaging variable. For governments and policymakers outside the United States, the calculation right now involves a very specific kind of risk management. Countries that export heavily to the American market, Vietnam, South Korea, Germany, Mexico, Japan, are running scenarios on what a 15% blanket tariff does to their export revenues, their employment figures, their current account balances. The Nikkei Asia reported that Japanese manufacturers were already accelerating plans to shift some production to U.S.-based facilities precisely to avoid tariff exposure, a trend that has significant implications for employment and industrial strategy across Asia. The Associated Press noted similar recalculations happening across Southeast Asia, where export-dependent economies built significant growth strategies around American consumer demand. A sustained tariff barrier disrupts that entire model. For businesses and markets, the picture is equally complicated. Small and medium-sized importers in the United States, the ones without the lobbying resources to secure carve-outs or exemptions, are now facing a double pressure. They may eventually be entitled to refunds on tariffs paid under the now illegal IEPA orders, but legal experts quoted by CNBC estimated that those refund processes could take years to resolve through the courts. In the meantime, they have already absorbed those costs. Some have passed them to consumers, some have restructured their supplier relationships, some have simply closed. The economic damage from the original tariff regime does not disappear because the Supreme Court called it illegal. It has already been distributed through the system. Now let us consider the alternative interpretation, because intellectual honesty requires it, and because some serious analysts do make this case. There is a school of thought, represented by economists at institutions like the Heritage Foundation and certain trade hawks within both parties, that argues the Supreme Court ruling and the political drama around it are ultimately less significant than the structural trade realignment that the tariffs were designed to accelerate. The argument is this: American manufacturing had been hollowed out for decades through trade policies that prioritize cheap imports over domestic industrial capacity. Tariffs, regardless of their legal mechanism, force a renegotiation of those terms. Some analysts quoted in The Economist argued that the 150-day window may be sufficient to pressure key trading partners into bilateral agreements that ultimately serve American strategic interests better than the previous multilateral framework did. They are not wrong that pressure can produce results. The question is whether the collateral economic damage justifies the approach, and that debate is genuinely unresolved. There is also the question of congressional behavior. The Trade Act of 1974 requires congressional approval to extend the tariffs beyond 150 days. That vote, if it happens, will be one of the most politically revealing moments in recent congressional history. Republicans who privately oppose the tariffs will have to publicly choose between their economic convictions and their political loyalty. Democrats will face their own internal divisions between labor constituencies that support domestic production protection and business-aligned wings that oppose trade barriers. The outcome is genuinely uncertain, and the outcome matters not just domestically. Trading partners are watching congressional signals as closely as they are watching presidential ones. Connect the dots and a larger pattern becomes visible. We are watching the early phase of a structural renegotiation of the global trading order that has been in place since the end of World War II. That order, built on multilateral institutions, agreed rules, and the assumption of American commitment to open markets, has been under increasing strain for over a decade. What the current moment represents is an acceleration of that strain to the point where institutional responses are visibly struggling to keep pace. The Supreme Court ruling is not the end of this story. It is a single institutional response in the middle of a much longer structural transition. Here are the three things that matter most right now. First, the 150-day clock on the new tariffs is the most consequential near-term variable in global trade policy. Watch what happens in Congress and in bilateral diplomatic channels over the next 5 months. Second, the Supreme Court ruling has opened a broader constitutional question about executive trade authority that will not be resolved by this single case. Expect more legal challenges and more rulings that progressively redefine what presidents can and cannot do with economic tools. Third, the global investment behavior of multinational companies is quietly reshaping supply chains in ways that will be difficult to reverse regardless of how the political and legal battles conclude. That underlying industrial realignment is the story with the longest consequences. If this analysis gave you a clearer picture of what is actually happening behind the headlines, that is what TC Explains is built for. Drop a comment below telling us where you are watching from and how these tariff developments are affecting your country or industry. We want to hear from people in export-heavy economies, from small business owners, from people in finance and trade. This channel is a space for informed global conversation, and your perspective makes the analysis sharper. If you are new here, look at what we have been building. Global analysis grounded in verified data, free of political theater. Before we close, this video is for educational and analytical purposes and represents interpretation of publicly available information from credible sources. We encourage you to explore multiple perspectives and verify independently. That is not a disclaimer to scroll past. That is actually the entire point. In a world moving faster than most institutions can track, the most valuable thing is not the loudest voice or the most alarming headline. It is the clearest analysis of what is actually shifting and why. The Supreme Court drew a line. The executive branch found a new road. The global system is adjusting, and understanding that pattern calmly, clearly, and precisely is how you stay ahead of it. Stay informed, stay analytical. TC explains.